Now, the Jordanian terror suspect Abu Qatada is to be released from prison on bail tomorrow after winning the latest stage of his lengthy legal battle over deportation. The Special Immigration Appeals Commission ruled that if he was deported to Jordan, it couldn't be certain that evidence extracted by torture would not be used against him. Well, you won't be surprised to hear that the Home Secretary, Theresa May, says the government will seek an appeal. But today's ruling could well be a decisive blow. Our Home Affairs correspondent, Simon Israel, reports.
This Islamist preacher, described as highly dangerous, has frustrated all government attempts to see the back of him for the last 11 years. Today was supposed to signal the moment his avenues for litigation finally ran out. But yet again, Abu Qatada, real name Mohammed Othman, has emerged the victor. This is deeply embarrassing for the Home Secretary. Both she and her ministers made strenuous efforts with the Jordanian authorities to guarantee a fair trial. But their efforts have proved useless. Why? Because what protects Abu Qatada from deportation is the fact that evidence obtained through torture could still be used against him in any trial. Back in April, after her trip to Jordan, the Home Secretary claimed they'd found ways round the European Court judgment, which barred Abu Qatada's deportation to face a retrial for acts of terrorism in 1998 and 2000.
I believe the assurances and the information we have gathered will mean that we can soon put Qatada on a plane and get him out of our country for good.
Very optimistic words. For today, that confidence had been replaced by anger, frustration and blame.
Mr. Speaker, notwithstanding the fact that I still believe that the European Court's judgment ruling was wrong, I also believe that we have obtained from the Jordanian government the information and assurances that would allow us to deport Qatada in compliance with that ruling and the law. That is why we disagree with today's decision. That is why we are seeking leave to appeal.
It is clear now that all of her promises and assurances were overblown, and her strategy has fallen apart as a result of this decision.
So is the game up for the government? The Honourable Mr Justice Mitting said there were only two ways to guarantee Abu Qatada a fair trial. Either Jordan altered its court procedures, he said, or...
It is for the prosecutor, not Abu Qatada, to prove to a high standard that the statements were not procured by torture.
His legal team emerged, cautious about the implications.
It's been a decade or more, but at the very least it's important to have fundamental concepts underpinned and reinforced. So that's what happened today.
For the last 7 years, Abu Qatada has either been in detention or under curfew. In 2005, detention without trial was ruled unlawful and he was released from prison and placed under house arrest. In the same year, the government signed an agreement with Jordan on assurances over human rights. Qatada is again detained pending deportation. In 2009, the law lords finally approved his deportation, but earlier this year, the European Court blocked it. Evidence, it ruled, may have been obtained through torture. The government sought another deal with Jordan, but today SIAC ruled it failed to address the torture problem and ordered Qatada's release. Tomorrow will see him leave Long Lartin prison. He'll be under stringent bail conditions, including a 16-hour curfew. The question is whether this 52-year-old will spend the rest of his life tagged and curfewed and living in the UK.
Simon Israel reporting.